Professor Laurie Ringhand from University of Georgia Law School. He's also teaching a class here this week on comparative constitutional law. And many of your students are now looking for jobs in the internship market, where they're all around and about. So as you saw, Professor Ringhand will speak about an issue that has been of some interest in the States over the past summer, let's say, and has even reached this part of the globe. I think everyone in Israel were following the drama pretty much to the same extent.
It's hard to avoid.
It is hard to avoid. But over the years, I guess, people here, certainly lawyers who sort of deal with Supreme Court towers and stuff like that, keep sort of following with a kind of a combination of dismay and appreciation or admiration of this process of judicial hearings for Supreme Court candidates. So we'll hear from you and your take on that. Then kind of open it to a discussion.
Thank you. I am going to begin my presentation with him and what you know.
This whole 2-week effort has been a calculated and orchestrated political hit, fueled with apparent pent-up anger about President Trump and the 2016 election, fear that has been unfairly stoked about my judicial record, revenge on behalf of the Clintons, and millions of dollars in money from outside left-wing opposition groups. This is a circus. I will not be intimidated into withdrawing from this process. You've tried hard. You've given it your all. No one can question your effort. But your coordinated and well-funded effort to destroy my good name and destroy my family will not drive me out. The vile threats of violence against my family will not drive me out. You may defeat me in the final vote, but you'll never get me to quit. Never.
So, whether one is a supporter or opponent of now Justice Kavanaugh's nomination and confirmation to the Supreme Court, very few people think that the process which culminated in that openly partisan testimony before the Senate Judiciary Committee represents a particularly good process. So I start with that to get the worst of our system on the table, because
It gets better for me.
because I'm going to spend the remainder of our time together attempting perhaps the impossible task of convincing you that despite its very distinct flaws, our confirmation process is actually doing some important work in our system of constitutional government. And while it's not perfect, it is the way it is for some specific and I believe really quite critical reasons. And that changing the process in ways that some folks are advocating for would actually harm, not help, our Supreme Court's legitimacy. So that's the overall goal, and I will probably not take a poll at the end to see how well I've succeeded. But in the course of trying to make the case for defending our confirmation process, I'm going to make 3 distinct points. First, our process is valuable, at least within our system, precisely because it is public. And suggestions to move it back to a more behind closed doors privatized process, I think fail to understand the reasons that our process is public and the value that that's adding to the system. Secondly, I think that the second kind of particular point I want to make is that the nominees who go through this process answer a lot more questions than they get credit for. And specifically, the questions that they do answer are playing an important role in our system in which that process validates constitutional change over time in a way that I think is particularly important within our constitutional regime. And then thirdly, and perhaps most challengingly, I will make the point that even allegations of personally disqualifying conduct, like what we saw here with now Justice Kavanaugh, are ultimately, while it's, I think it's a closer case, ultimately much better ventilated through a public process than a private process. So with that as my mission, let me start with, what did you say? Oh, no, not him again. Let me start at the beginning. Within our system, why does the process look the way it does? Well, this is Article 2 of the U.S., part of Article 2 of the U.S. Constitution. And what it says is that the President, with the advice and consent of the Senate, shall appoint judges of the Supreme Court. Now, the importance of this text is that from the very beginning of our constitutional system, the judicial appointments process has been an intentionally, self-consciously political process. The Supreme Court in our system sits within our systems of checks and balances. It doesn't exist by our very own constitutional structure outside of that. So the Supreme Court is not an entity that sits outside of politics in its entirety. It is an entity that is part of the system in checks and balances, and that's baked into our constitutional cake by making the appointments process itself, by putting that process under the control of the political branches of government. So it's not surprising then that throughout our history, both presidents and senators have taken their responsibility in that process very seriously. Our presidents and our U.S. Senate have always known that who sits on the court matters. There is a rhetoric around the U.S. appointments process that likes to tell a story that the politicalization of the process started maybe when Brown v. Board, our segregation decision, was issued, maybe in the 1980s when Judge Bork had his famous confirmation hearing that generated the verb borked in our vocabulary, in which he was unsuccessful in his appeal to the court and was voted down by the Senate. Neither of those things are true. Our process has been hotly contested among the political branches of government since the very beginning. So just as a few very quick examples of that, our earliest and most famous presidents imposed what today we would call litmus tests on their selection of nominees to sit on the high court. President Lincoln, our Civil War president, it was not controversial when he announced that he would only appoint pro-union judges to the Supreme Court. His predecessor, President Grant, explicitly said he was only looking for nominees who would overturn a very particular decision that involved financial policy in the United States. And Franklin Roosevelt, the Depression-era, World War II-era judge, was also equally explicit and said he was only going to appoint justices to the court who would uphold his New Deal social welfare programs. So there's nothing new in the notion that presidents make their choices with an eye and an acknowledgement that these are not fungible, interchangeable jurists. They have opinions, and their opinions about constitutional law will matter politically. Nor has the Senate ever been a rubber stamp, an automatic approval for the president's choices. George Washington, our very first president, had his Chief Justice nominee rejected by the U.S. Senate because that nominee favored the British over the French, and that mattered a whole lot, and they were very angry at each other, and they rejected President Washington's nominee. And of course, since then, over the course of time, in the 19th century, in the 1800s, the Senate rejected about a third of presidential Supreme Court nominees. The rate today is nowhere near that. So if anything, our process has become less political over time, not more so. But what has changed, those politics, the politics of Supreme Court confirmations, used to happen between the president and the senators in those famous smoke-filled back rooms. It was always political, but it was out of the public eye. So what has changed is our process is now political and public. That change began at a very specific moment in time. It began in 1939 when Felix Frankfurter became the first Supreme Court nominee to testify in public under oath and take unrestricted questions from the U.S. senators in that very public space. And I want to dwell for a moment on the Frankfurter nomination and how he ended up testifying before the Supreme Court. Because he did this happened for, again, a very particular reason. It happened because of him. Does anyone know who this is? No, there would be no particular reason why you would. This is Hugo Black. Hugo Black became a justice of the Supreme Court. He was nominated by President Roosevelt in 1937, which is 2 years before Felix Frankfurter was nominated and before Felix Frankfurter testified. So Hugo Black was nominated by Roosevelt 2 years before Felix Frankfurter. Black was a sitting U.S. senator, and he was confirmed in one of these private behind closed doors confirmations by his peers in the Senate 5 days after he was nominated. But there was a very big problem with this, because the U.S. senators knew, but did not tell anybody, that Hugo Black had had a lifetime membership in the Ku Klux Klan, the white supremacist hate group in the United States. He was a senator from Alabama. Alabama is in the southern United States, and being a member of the Klan was a reasonable career move for him, frankly, in his youth. He had accepted a membership from the Klan and had never effectively rescinded it. And the U.S. senators knew that. And they decided, in the privacy of their own wisdom, that nobody else should know about that because it wasn't a big deal. That news burst onto the national scene a few days after Hugo Black was confirmed. The journalist who broke the story won a Pulitzer Prize for it. The president and then Justice Black had to go on national radio and explain and apologize for not discussing this publicly before the confirmation. And the important point of this for our purposes is the Senate Judiciary Committee learned a very important lesson through this episode. It learned that from that point forward, an expanded and empowered public was simply not going to tolerate those types of decisions, those types of judgment calls about what matters when deciding who should sit on the Supreme Court, to be made privately behind closed doors. And in fact, the Senate Judiciary Committee at the time made exactly that promise. He said, from now on, we are going to be more transparent about our decisions. And that's why that's why Felix Frankfurter 2 years later was sitting before the Senate Judiciary Committee giving his open testimony. So this public expansion, this expansion of public engagement and empowerment that happened during this era, it happened for some particular reasons. It happened because of the 19th Amendment. We literally had an expanding democracy. Women were given the constitutional right to vote. It happened because of the 17th Amendment. The 17th Amendment created the direct election of U.S. senators. Prior to that, U.S. senators had been chosen by states. After that amendment, they were directly elected by the people. And of course it happened, the actual Martin Luther King's actual civil rights movement happened a bit later, but the emergence of the civil rights movement in this era between the wars was a growing racial recognition of racial inequality and an empowered African American population that was claiming its space, its place in our system of democratic self-government. So all of these phenomena resulted in an expanding awareness of who the senators have to be accountable to and what they have to be accountable to. We had a growing, robust democracy. This was a huge expansion of American democracy over the course of our history. And as that became more robust, the Senate recognized that it also needed to be responsible for that. So that's the story of how the process became public. The Senate's increased responsibility to a larger, expanded, more engaged democratic system that expected more from the US Senate than it had seen before. But of course, that doesn't fully answer the question of whether that's good. It could be democratic, it could be robust, and it could still be kind of bad. I think it is a good thing. And to talk about why it's a good thing, we have to think hard about what it is we think US Supreme Court justices are doing. So for that, I'm going to turn to an expert, President Obama.
Thank you. Thank you. Well, I'm excited too. Of the many responsibilities granted to a president by our Constitution, few are more serious or more consequential than selecting a Supreme Court justice. The members of our highest court are granted life tenure, often serving long after the presidents who appointed them. And they are charged with the vital task of applying principles put to paper more than 20 centuries ago to some of the most difficult questions of our time. So I don't take this decision lightly. I've made it only after deep reflection and careful deliberation. And while there are many qualities that I admire in judges across the spectrum of judicial philosophy, and that I seek in my own nominee, there are a few that stand out that I just want to mention. First and foremost is a rigorous intellect, a mastery of the law, an ability to hone in on the key issues and provide clear answers to complex legal questions. Second is a recognition of the limits of the judicial role, an understanding that a judge's job is to interpret, not make law, to approach decisions without any particular ideology or agenda, but rather a commitment to impartial justice, a respect for precedent, and a determination to faithfully apply the law to the facts at hand. Now, these two qualities are essential, I believe, for anyone who would sit on our nation's highest court. And yet these qualities alone are insufficient. We need something more. For as Supreme Court Justice Oliver Wendell Holmes once said, "The life of the law has not been logic, it has been experience." Experience being tested by obstacles and barriers, by hardship and misfortune. Experience insisting, persisting, and ultimately overcoming those barriers. It is experience that can give a person a common touch and a sense of compassion, an understanding of how the world works and how ordinary people live. And that is why it is a necessary ingredient in the kind of justice we need on the Supreme Court.
So that, of course, was President Obama, who was both President Obama and law professor Obama at an earlier stage in his life. And I would posit to you that that clip represents both of those facets of his professional identity. What Professor Obama tells us is that to be a Supreme Court justice, you need a rigorous intellect, judicial humility, a lack of hubris, and life experience. I think all of us law professors would agree that that's a good list. Those are good things for Supreme Court justices to have.
Well, I would say that that telling everyone that judges do not make law is a good in terms of pleasing the public, but of course it's false.
So President Obama, the politician, was also in this clip, right? And President Obama, the politician, tells us that a rigorous intellect enables a judge to find clear answers. And President Obama, the politician, tells us that judicial humility, a lack of hubris, is knowing that judges interpret but not make law. Of course, and as your dean says, that's not true. It's not true, perhaps, particularly in the US system. Our Constitution is 229 years old. It has the most contested provisions of it are human rights written in very abstracted, generalized terms, like freedom of speech and equal protection. Those terms don't define themselves. Yet much of the public story that we tell about constitutional law pretends that smart justices acting in good faith will find one and only one correct answer to constitutional conflicts arising out of those provisions. And while that view might be appealing, it's simply not the case that you can eliminate judicial discretion in hard cases. That's what makes them hard cases. The tools of legal reasoning can constrain judicial discretion, but they can't entirely eliminate it. So Supreme Court justices make choices, and those choices operationalize the words of the Constitution. I'm going to let another individual,
Thank you.
Justice Kagan, who's going to be on the screen in just a moment here, talked about this judicial function at her confirmation hearing. And I will let her say her piece, but I want to take just a moment while she's here. Remember that face. In my opinion, this is going to be the next president of the United States. So you can say you heard it here first.
Amy, what's her name?
Amy Klobuchar. Her biggest problem is no one can say her last name. It is Amy Klobuchar. She is currently a senator from Minnesota.
You know, when Chief Justice Roberts was nominated to the Supreme Court and sat in the seat you're currently in, he famously told this committee that judges are like umpires. Umpires don't make the rules, they apply them. He said that it was his job to call balls and strikes. And I was wondering if you could just talk about that metaphor. Do you think the balls and strikes analogy is a useful one, and does it have its limits?
Senator Klobuchar, I think that's correct in several important respects.
You're also going to make a bunch of stupid baseball analogies here.
So let me start with the ways in which I think it's an apt metaphor. The first is kind of the most obvious, which is that you expect that the judge, as you expect the umpire, not to have a team in the game. In other words, not to come onto the field rooting for one team or another. And, you know, if the umpire comes on and says, you know, I want every poll to go to the Phillies, that's a bad umpire. And is that your team?
Not exactly. The twins, I was pointing to Senator Compton, I'm sorry. And same for the judge. So you know, to the extent of what the umpire suggests, that there's got to be neutrality, that there's got to be fairness to both parties, of course that's right. The second thing that I think is right about the metaphor, and I think that this is what the Chief Justice most had in mind, if I remember his testimony correctly, is that judges should realize that they're not the most important people in our democratic system of government. They have an important role. Of course they do. We live in a constitutional democracy, not a pure democracy. And judges have an important role in policing the constitutional boundaries of our system and ensuring that governmental actors, other governmental actors, don't overstep their proper role. But judges should recognize that that's a limited role, and that the policymakers of this country and that the people who make the fundamental decisions for this country are the people and their elected representatives, whether in Congress or in the executive branch. And I think that that's right too, as I've tried to say on many occasions throughout these hearings. I suppose the way in which I think that the metaphor does have its limits, and I believe that this is in line with what Mr. Ayers was talking about, was that the metaphor might suggest to some people that law is a kind of robotic enterprise, that there's a kind of automatic quality to it, that it's easy, that we just sort of stand there and, you know, we go ball and strike and everything is clear cut, and that there's no judgment in the process. And I do think that that's not right, and it's especially not right at the Supreme Court level, where the hardest cases go, and the cases that have been the subject of most dispute go. And as to that, I think that there is, judges do, in many of these cases, have to exercise judgment. They're not easy fools. That doesn't mean that they're doing anything other than applying law. I said yesterday on a couple of different occasions, it's law all the way down. You know, you're looking at text, you're looking at structure, you're looking at history, you're looking at precedent. You're looking at law and only at law, not your political preferences, not your personal preferences. But we do know that not every case is decided 9-0, and that's not because anybody's acting in bad faith. It's because those legal judgments are ones in which reasonable people can reasonably disagree sometimes. And so in that sense, law does require a kind of judgment, a kind of wisdom.
So Justice Kagan is making an important distinction here. She draws a distinction between judges who are partisan and judges who are ideological. Judges should never be partisan. A judge or justice who is partisan will issue the decision based on who the party is sitting in front of them. So our famous Supreme Court case of Bush v. Gore that effectively decided the presidential election of 2000 was criticized by many people for being partisan, in that the justices took opposite sides on the constitutional question of equal protection than they normally did in the course of their jurisprudence. And it was accused of being partisan because the accusation was these justices would not have done that if the parties in the case had been reversed. That is different than a justice who is ideological. In uncertain constitutional abstract questions of these broad human rights documents, justices will have different approaches to what they believe should be prioritized in the context of contested constitutional meaning. That type of ideological judging can be, as Justice Kagan says, law all the way down. It still is legal reasoning. It's reasoning constrained by the rhetoric and tools of law, but it is not, to use her term, robotic. They are choices that justices and courts make from the legally acceptable or viable options presented to them in a particular case. And that's where our very public Supreme Court confirmation process comes in and plays an important role. Throughout history, over the course of time, our Supreme Court makes these types of constitutional choices. It has to look at a legal problem and examine the variously legal acceptable answers that could be made to the question presented. And they pick one. And then over the years of subsequent confirmation hearings, we argue about whether they made the right choice. And when something becomes fully settled, genuinely embraced and accepted by the people into our real constitutional consensus, it becomes a true litmus test where a nominee has to sit there in public and under oath and say, yes, I agree that that was correctly decided. And then that issue enters our canon as something we're not going to fight about anymore. Now, our system rarely gets credit for playing this role because we spend all of our time, in the interest of time, I'm not going to play this full clip, but we spend all of our time paying attention to the questions nominees don't answer. Nominees do not answer questions about Roe v. Wade. They are not going to. Our abortion decision, constitutionalizing the right to abortion. They don't answer questions of this particular clip is 5 minutes of justices saying, I'm not going to answer that. They don't answer questions about current controversies. And the senators will poke and prod and try to get them to say, but that really is settled. And they're going to say, no, no, no. Of course Roe v. Wade isn't settled in American law, in the sense that it is a previously controversial decision that has now gained very broad acceptance. That has not happened to Roe v. Wade. But there are lots of things nominees in public and under oath do answer. So compare what we hear. Compare what we hear about Roe v. Wade and the constant non-answering. I guess you have to listen to this. I can't make it go
is that I
forward.
am opposed to it as a matter of birth control or otherwise.
Can I proceed without listening to it? Okay.
The subject of abortion.
Just listen to it. So we will listen to the abortion clip where they all refuse to answer before we move on.
Abortion is a valid one, in my view, for legislative action, subject to any constitutional
Sandra Day
restraints or
O'Connor in
limitations.
1986.
Do you expect to overrule the Roe versus Wade Supreme Court decision if you're
86.
confirmed?
Senator, I don't think it would be proper for me to answer that question. Let's assume that I have people arguing before me to do it or not to do it. I think it's quite a thing to be arguing to somebody whom you know has made a representation in the course of his confirmation hearings.
If I had an undisclosed intention or a fixed view on a particular case, an absolutely concluded position on a particular case or a particular issue, perhaps I might be obligated to disclose that to you. I do not have any such views with reference to privacy or abortion. I have not got any agenda on what should be done with Roe v. Wade if that case were brought before me. I will listen to both sides of that case. I have not made up my mind, and I do not go on the court saying I must go one way or I must go another way.
I have no reason or agenda to prejudge the issue or to predispose to rule one way or the other on the issue of abortion, which is a difficult issue.
This is something central to a woman's life, to her dignity. It's a decision that she must
She always
make
looked old, see?
for herself. And when government controls that decision for her, she's being treated as less than a fully adult human responsible for her own choices. It is essential to woman's equality with man that her choice, that she be the decision maker, that her choice be controlling.
The case of Roe versus Wade has been the law for 21 years or more, and it was recently affirmed by the Supreme Court of the United States in the case of Casey. That is the law. The questions that you're putting to me are matters of how that basic right applies, where it applies, under what circumstances. And I don't think I should go into those for the reason that those are likely to be the subject of litigation in front of the court.
Your testimony read to this effect, and it's been widely quoted. Roe is the settled law of the land. Do you mean settled for you, settled only for your capacity as a circuit judge, or settled beyond that?
Well, beyond that, it's settled as a precedent of the court, entitled to respect under principles of stare decisis. It is settled as a precedent of the court, yes.
Do you believe it is the settled law of the land?
Roe versus Wade is an important precedent of the Supreme Court. It was decided in 1973, so it's been on the books for a long time. It has been challenged on a number of occasions. It's a very important precedent.
Is it the settled law of the land?
It is a precedent. If settled means that it can't be re-examined, then that's one thing. If settled means that it is a precedent that is entitled to respect as stare decisis, and all of the factors that I've mentioned come into play, including the reaffirmation and all of that, then it is a precedent that is protected and entitled to respect under the doctrine of stare decisis in that way.
In your opinion, is Roe settled law?
The court's decision in Planned Parenthood versus Casey reaffirmed the core holding of Roe. That is the precedent of the court and settled in terms of the holding of the court.
Do you believe the Constitution requires that the health of the mother be protected in any statute restricting access to abortion?
I do think that the continuing holding of Roe and Doe versus Bolton is that women's life and women's health have to be protected in abortion regulation.
Can you tell me whether Roe was decided correctly?
Senator, again, I would tell you that Roe versus Wade, decided in 1973, is a precedent of the United States Supreme Court. If I were to start telling you which are my favorite precedents or which are my least favorite precedents, or if I view precedent in that fashion, I would be tipping my hand and suggesting to litigants that I've already made up my mind about their cases. That's not a fair judge.
So compare that to this.
I hope we will receive your frank and candid and complete responses to the questions we asked today. To start my inquiry, I want to discuss with you the Brown versus Board of Education, which you have already mentioned this morning, which I believe is the most important civil rights decision in our lifetime. In Brown, decided in 1954, the year before you were born, the Supreme Court concluded unequivocally that black children have the constitutional right to be educated in the same classrooms as white students. The court rejected the old doctrine of separate but equal, finding that it violated the Equal Protection Clause of the 14th Amendment. In considering the issues raised by Brown, the court took a broad and real-life view of the question before it. It asked, does segregation of children in public schools solely on the basis of race, even though physical facilities and other tangible factors may be equal, deprive the children of the minority group of equal educational opportunities? So do you agree with the court's conclusion that the segregation of children in public schools solely on the basis of race was unconstitutional?
I do.
And do you believe that the court had the power to address segregation of public schools on the basis of the Equal Protection Clause of the Constitution?
Yes.
So there you have it. The point being, of course, that when we talk about nominees refusing to answer questions, we are looking at a very narrow lens of what is happening at these confirmation hearings. The nominees are refusing to answer questions about genuinely unsettled issues. But what they are doing, as we just saw here in Brown, is once an issue that used to be controversial, and Brown, of course, was very controversial, and controversial as a matter of law, not just as a matter of kind of social policy. Once something has genuinely entered our constitutional consensus, these nominees, in public, under oath, affirm their agreement and acceptance of that consensus before they can take their seat on the high court. In a system like ours, that is a very important mechanism where the judiciary says to the political branches and to us, the public, yes, we used to fight about that. We used to think that there were multiple viable legal answers to that question. We don't think that anymore. Whatever the merits used to be of that discussion, we've had it, we're done. And we accept that this is what the US Constitution means to us today. And to do that in public and under oath is an important way of validating those choices made by the court. And it wasn't always that way, even with Brown. Justice Potter Stewart was the first Supreme Court nominee appointed after Brown. And he danced around Brown, unfortunately it wasn't televised yet, but he danced around Brown the way today's nominees dance around Roe. There were about 10 pages of written transcripts where he was arguing with the senators, and the senators were arguing amongst themselves about whether he had to answer whether Brown was correctly decided. And the closest he came, and this is such a great quote, I'm going to quote it directly, the closest he came to answering that question was he said, "No one should vote for me on the assumption that I am decided for certain against that case." That's it. That's as much as he was willing to say. And of course, Brown is not alone in this regard. It's the most crisp example, but there's in fact quite a list of cases within the US constitutional canon that used to be deeply legally controversial and simply aren't anymore. Brown, of course, a basic right to privacy, under the Constitution. The notion that we would have heightened review by judges for gender discrimination, congressional powers to enact certain important civil rights legislation, a First Amendment protection that goes beyond political speech, personal right to bear arms since Heller. We've also rejected consistently Dred Scott and Plessy v. Ferguson, which are a slavery and desegregation case, Karamatsu, the Japanese internment case, of course, and the Lautner, which restricted the power of Congress to regulate in the economic realm. So there is a lot of this validation going on of nominees who are expected to say and affirm this consensus. And I think that's good. I think this is an important part of this process, that nominees in public and under oath have to actually affirm before they can take their seats that even though we used to bicker about those issues, we don't anymore. It is the real way that nominees tell us that they are in the mainstream. But of course, there are still problems. There are problems like we saw with Justice Kavanaugh. And the particular problem there is, even if you accept what I've said so far about the value of a public process to affirm previously controversial decisions, does that apply to these questions of personally disqualifying conduct? For that also is not a new question. And I'm going to show one more clip for you here. This is gone. Where did it go?
You're going backwards.
I am, because I'm wondering if when I was moving them around a minute ago. Huh. It was a great clip. I fear I may have deleted it. I'll tell you what it was. I can't do it justice. This question of personally disqualifying conduct, of course, is not new either in our system. We had the Clarence Thomas hearings, which some of you may remember. Clarence Thomas was an African-American jurist nominated to the court 30 years ago. And he was in the process of his confirmation. A former employee of his, Anita Hill, came forward and accused him of sexually harassing her in very explicit ways while he was her boss at a public agency. And it was very explosive, particularly the mix of sex and race politics in that forum and in that time and place. And Justice Thomas issued this extraordinary statement, much like we saw from Brett Kavanaugh, when he went in after these accusations were vetted and after Anita Hill testified. He went into the confirmation room just like Kavanaugh did and kind of invoked his rage at the accusation and called it a high-tech lynching of uppity blacks, which has a very salient racial connotation in the United States, of course. So what do we make of that? Even if I am right that the public affirmation of these things has some role, do these types of personally disqualifying conduct, should that still be conducted in public? My answer again is yes, although I think it's an uncomfortable answer. It's yes for a particular reason. And it brings us back to this. Remember President Obama telling us that the life of law has not just been logic, it has been experience. Of course, what he means when he says this is that the lives we live, who we are, influences how we see facts and how we see law. And Justice Obama invoked that when he nominated Sonia Sotomayor. And many of you may remember this nomination. Sonia Sotomayor was is our first Latino justice. And she had made this comment during several speeches that she gave prior to her nomination. She said, "I hope a wise Latino woman with the richness of her experiences would more often than not reach a better conclusion than a white man who hasn't lived that life." She heard about this at her confirmation hearing, and her point here, her statement here is of course very different than the accusations against Thomas and Kavanaugh. But the importance of all of them is that some people thought that they evidenced a disqualifying view of the world and of her personal life and experience that rendered her unfit for the bench. In other words, the similarity is that we disagreed about what the effect of this conduct should be. We disagreed about whether the accusations against Clarence Thomas and Brett Kavanaugh should disqualify them from the bench. We disagreed about whether an expression of what her opponent saw as bias should disqualify Sonia Sotomayor from the bench. And of course, going back to Hugo Black and the Klan, that was a disagreement about whether his historic membership in the Klan should or should not be disqualifying to sit on the bench. And so my point is this: as long as we disagree about what type of personal conduct is disqualifying, airing these disputes in public may be the best solution, as opposed to going back and trying to do what the Senate Judiciary Committee did with Hugo Black, which was to air them in private and not let the public see and hold accountable the choices that our senators are making in this space. That's messy, it's unpleasant, and it will be ugly. I'm not convinced there is a better way, as long as we disagree about whether or not the conduct itself should disqualify you from the bench. All right, that is all I have for you here today. And